Good morning and welcome to the First District Court of Appeal. We have two cases on our OA docket this morning. We'll take them in the order in which they were noticed. The first case is case number 25-79, Estes versus Palm Beach County School District et al. Mr. Porcher.
I'd like to reserve 7 minutes for rebuttal.
Thank you.
May it please the court. Randall Porcher on behalf of the appellant, Miss Nancy Estes. In the end, this case turns on the meaning of the word toll. There is no other issue. Now, admittedly, my brief went into grammar and did a deep dive, and I'm going to try to stay away from that today, because if toll is given the proper meaning, everything else falls into place. So the meaning of the word toll here pertains to its operation on a statutory limitation. Its ordinary, expected, and in fact, its dictionary meaning is to suspend or pause. It both describes the verb and it describes its mechanics. No other word will do such a thing, and we have developed a word for that because when we say toll in legal parlance in a statute, absent some exceptional definition, that is precisely what it means. So there's 4 reasons why it should be interpreted that way, and we start off with that is.
So, Mr. Porcher, do we have a problem here with going with a textual approach, because this court has said this court in the past has used a more purposivist and discerned the intent of the legislature and went in another direction, and so toll doesn't mean pause or abate like it would in Black's Law Dictionary, but it means extend in some fashion.
Well, we'll get to that. So do you have a problem? I would think not, mostly because Phillips did not give a definition of the word toll.
But I mean, isn't Phillips what we have here, though? I mean, you've got exactly the same factual situation, it seems, where either the subsequent provision of services applied the 1 year, or it didn't, right? I mean, why?
Oh, no,
I
have to concede that if Phillips is looked at from 30,000 feet and you say, what is the result of Phillips? I still question the result, because the result is, what does toll mean? And so if Phillips gives you the outcome and the input, I lose all day long. But Phillips also stands for something that this court should reconsider. The court said the word toll does not have a definition in the workers' compensation statute. That should be a signal that it doesn't have a special definition. But instead of saying, oh, it doesn't have a special definition, let us turn to a dictionary, they said, so there is this interpretation, but we don't feel, or we do not believe that that's what the legislature intended. Not focusing on the word. In fact, they elided that. Yes.
You're focusing on the word toll in 449.19, but don't we need to read the whole sentence both there and then Judge Tannenbaum in his Ortiz concurrence, equates it to 95.091, the tolling of civil statutes, but the two sentences as a whole are different. 440.19.2 shall toll the limitations period set forth above for 1 year from the date of such payment, where 95.051.1, the running is tolled. So I mean, pretty clearly 95.051 tolled there means paused, but could not tolled in 440.19 mean extended, since we have a year period there.
And I will get there, but extending is a categorical expression. If you look at the result, I once had 6, I now have 36. Or so I extended my takings or whatever. But it doesn't explain the mechanics by which that was done. I could have added 30, I could have multiplied by 6, I could have added 2, multiplied by, there's a million ways to get there. And we're talking about the statutory assertion of time. So time has its own language, and extend is the vaguest term that you would use. And there is a way to show could we extend time by pausing the time in motion. How could we extend to the observers outside? How could we extend it by pausing the running of the time? And we have a word for that, and it's toll. So extend doesn't answer the question, and in fact begs the question. Now, I have to admit, the Phillips court said what they said, but fortunately they showed their work as well. So it stands for a non-definition of toll. You can't get there. And I struggled. I mean, I
And did the
legit.
Supreme Court, the year after, you cited the Henke case, Florida Supreme Court case in your papers, a year after Phillip, they addressed the definition of toll in a statute of limitations context, and it said it means abate. Does that change our calculus in evaluating Phillip?
I think it certainly could. And, you know, if the purpose of textualism is to bring adherence and integrity and fidelity to the law, I think Phillips stands out there as there's no statutory definition of toll, which should send off alarms, which is, okay, so it's the ordinary and reasonable reading, because statutory definitions are only for specialized or modified. And they relied on Best, which cited Black's Legal Dictionary, the definition of toll, and they said, we just don't believe that's what the legislature meant. So if someone tried to use Phillips today to say, this is how we ought to arrive at the meaning of a statute, what do you believe? I think
Phillip
you'd
has
say
only
Phillips.
been cited once, right? As I looked at Westlaw, Phillip's been cited once in 30 years. And so it seems like there's not much that's written on Phillip.
I don't think there is a lot dressing.
Well, and also in Phillip, can you tell me what the how much time passed between the accident and the initial provision of benefits?
That I cannot. On rebuttal, I can.
Yeah, you
perhaps
probably
do that.
can't because I'm not sure they
Oh.
mention it. And my point in that is, despite everything that Philip said, it still was addressing a different issue, I think, than it is like Best. I mean, Best was addressing a different issue than we have here. And so even though Philip goes off and, relies on Best and then, does what they did, and to what extent would a decision like that count as a holding in a case like this when they don't even address how the tolling actually would work? They just kind of guessed at it or passed by it and
Yeah.
didn't really show their work. I disagree with you on that. I mean, they just cite Best and just say, yeah, this is how we think it should work.
They inverted the holding him. Yeah.
Yeah.
So, stare decisis, I mean, it's Latin for we allowed the thing that has been decided to stand, but the question is what has been decided? And really what they decide there is what the judge there, they weren't going to use a dictionary because there wasn't a definition, and there are two interpretations, and we're going to go on our judicial belief. But the problem is it leaves toll as a verb without meaning. And I agree, Judge Bilbrey, I agree that you don't look at one word and fly speck it, but it is the predicate of the sentence on a statutory provision that accounts for the time in the running and a time limitation. So I don't think it's fly specking to say that toll should get its ordinary and reasonable reading in that context where it is the centerpiece of the statute and everything else falls into place once you get toll right. And that's why I said it turns on toll. I did the grammatic takedown, and I apologize to anyone who had to read it, but I was really trying to find any other verb that would fit. And, quite simply, extend does not do it. It doesn't tell of the mechanics. Extends comes from, it's figurative speech, because it usually talks about a physical item. We extend something, we stretch it. So we don't extend time. Now to the observer.
But the Supreme Court has actually been more specific on that and made the distinction between toll and extend, hasn't it? I mean, extend is a different concept, as is revive. And wasn't that the state of the law before 1994?
Yes, and I haven't gotten to my 4 reasons. Now, told in 440.19 sub 2 is not an isolation or a one-off. In fact, it was created over 440.19 sub 5, which has been in the statute since any of us were born. And it says the statute of limitations is told during the minor or incompetency of a person, is told. Use the word extend if you must, but then the question then becomes, how are you extending it? Oh, by pausing it during that period. And then 440.192 uses the word toll. So the fixed meaning canon would say, well, when they put the word toll in there into a 6 subsection statute that is not indented, it's integrated, it's a fixed meaning, it's consistent meaning, and it should be read harmoniously. So I recognize that Phillips says what it says, and I hope I did a respectful job with that in my brief. But the question is, it's not a substantive right. The best day for Miss Estes is she gets to have the merits of her case heard. Now, that's a good thing, and it's a wonderful, but she doesn't get any extra money. She doesn't get any extra rights, and it is a procedure. And so nobody has a vested right in a procedure. The case is decided on its merits. And,
I'm sorry, but you're running into your rebuttal.
Oh.
I don't want to take up too much, but have you found another instance in all the decisions of the Florida courts where toll has been read to mean extend?
So I think it has been used as a synonymously, where categorically.
But functionally,
functionally it can't.
I mean,
it
people
cannot.
call it, sometimes erroneously refer to it as extend, but functionally,
No, and
as a
mechanically,
tacking on of a period of time to the end of the statute. as opposed to
mechanically,
stopping
the
it.
word extend means nothing. You can extend by adding, you can extend by multiplying, you can extend by looping, you can extend by reviving, you can extend by pausing the time that's running. And we have a word for that, which is toll. So extend really is a broader category. And so Judge Tannenbaum, I don't know if there's such a use, but if there is such a use, I would challenge them to show me the mechanics, because it can't be done. I mean, that's the good thing about math, is there's only so much that can be done, then you have to prove it. So I thank you. I've run into my rebuttal time.
Thank you.
Thank you.
Mr. Wagner?
May it please the court. My name is Bill Rogner. I represent the Palm Beach County School District. Phillip was my case. That case was handled by my firm, and the facts were identical, and it says so in the body of the opinion. It says that the petition was filed more than 2 years after the date of the accident and more than 1 year after the last provision of benefits.
But does it say when the initial provision of benefits was done?
It doesn't say it.
So then we don't know. It's not the same issue, then, is it?
Well, I do. I know it was the same issue. It was a compensable
Well, but we
claim.
don't. Reading
I
the
understand.
case, no one knows that.
I understand. Let me give you the big picture here. So I was doing this full-time work in 1994. This is all I've ever done in my life, right? And I was doing this full-time. And the prior version of the statute did not have the word toll in it. What it said was you get 2 years, but it can be extended. It didn't say extend, but it said may be filed within 2 years after the last payment of compensation or the last provision of remedial care. We called that provision of benefits a tolling event. That's what we called it.
Who's we?
It was the practice,
industry?
the JCCs, and you. I looked up last night. I found 11 cases between 82 and 92, just the dates I looked, where the court referred to the payment of benefits as a tolling event. That's what tolled the statute. And so what would a reasonable reader have believed tolling meant when that word was put in Chapter 440 in 1993, effective in 1994? And I assert that a reasonable reader would have believed that it was an extension. And we made that exact argument when we brought the Phillip appeal. And here's the key to the case for me, is the court, sometimes I get pushback, they'll say, well, that's just dicta. That's just dicta. That's not central to the ruling of the case. And the court said, And it's exactly the way it's worked. It's been settled for 25 years. It said, we thus hold. A claimant is barred from filing a PFB unless the claim is filed during the longer of the two periods of time. 1, within 2 years from the date of the injury, or 2, within 1 year from the payment of indemnity or the furnishing of treatment. We hold. And that's how multiple generations now of lawyers and claims adjusters and everybody else has interpreted the statute of limitations. And my problem...
Why did the Florida Supreme Court the very next year say that tolling in the context of statute of limitations means a pause?
Okay,
means
well, now I go back to calling
that
that...
seems like they are doing, in fact, the heading is plain meaning. I mean, they are doing plain meaning
I
statutory interpretation work.
I absolutely understand that, Judge. I understand that. And I looked at the cases, Judge Tannenbaum, you've written a lot about this. And I looked at the cases that you've cited. And, you know, the Hankey case is a Med-Mal case. The Herndon case is a Chapter 95 case. The McBride is a comp case, but addressing a completely separate issue involving the dismissal and whether dismissals of PFBs told the statute. And so I don't think any of those are anything more than dicta.
Did the Supreme Court talk about the word toll in those cases?
Sure, they did.
Yeah.
I
And
understand.
didn't the Supreme Court say that wherever, or I'm roughly paraphrasing, but where it appears in a statute of limitations context, this is what it means?
Your Honor,
That's how they got
language
from
that's
Chapter
found.
95 to
I-
Chapter 766.
I understand. I
Right.
understand. And I guess
And didn't the Supreme Court also lay out in detail I didn't mention the clock first, the Supreme Court mentioned the clock first, which you've taken issue with repeatedly. So the Supreme Court has explained exactly how that word typically is used, has historically been used and understood. And you're arguing that that's wrong, that the word, if we go back before Philip and Best, and just go back, and you're looking at the word off the bat, we're trying to find the original meaning of that word.
Right.
Are you asserting that the word toll means something other than suspend?
I am not. And if we were sitting here in 1999 arguing this case, if you had been sitting there instead of the three other judges that were sitting there at the oral argument held on the Phillip case, and we were considering this as a matter of first impression, I understand the legitimacy of the point of view of my opponent. My question, or my point, though, Judge, in response, is it's a matter of procedural. It's a procedural issue for me. And the reason is, this is not a vague statement about how this statute applies. And I would point out, since 1999, when Phillip came out, the legislature has amended Chapter 440 almost every single year. Almost every single year. And they've never touched 440.19. And this court wrote, with Judge Tannenbaum in dissent, in the Guglielmo case, this year, the legislature is presumed to know the judicial construction of existing law when it amends a statute and to have adopted the prior judicial construction unless a contrary intention is expressed. If the legislature thought you had whiffed in 1999 when you ruled exactly how our statute of limitations applies, they could have corrected it. So they have tacitly
But doesn't
approved.
that principle apply to the actual provision that the legislature is amending? Because that concept doesn't work, generally speaking, because every legislature is different. There are a variety of political reasons why a legislature doesn't enact a correction, and it otherwise is subverting the Constitution to argue, well, the legislature accepted by not acting, so that's approval of what we've said. That it doesn't work constitutionally, does
Well, Your Honor, the other thing that I would point out, and it's really a really important thing to us right now, and we're debating this, is my position is, and Judge Bilber, you wrote about this in the Awolowo case in 2024 in dissent. You were in dissent, but you wrote about this. I have believed forever, and I've been told by judges in this court when I'm up here making an argument, they'll look at me and they'll say, Mr. Rogner, are we not bound by this panel decision unless and until we go in bonk and recede from it? At which point I usually pivot to trying to distinguish my case or argue that it's only dicta. And it is my belief that this is an absolutely clear holding, and it's important because the entire industry has functioned under this definition, or this holding that you gave us in 1999. And if the court is going to change it, should it not go en banc to change it? And the reason I say that is I submit that what we're being potentially encouraged to do is to bring arguments and issues to you again and again, hoping that I get a different panel. Because if you're not bound, if this panel is not bound by another panel, then where is the finality? So what I do mostly in my job is I answer questions for clients. Bill, I've got this fact pattern. What's the answer? And I get the answer not just from the Constitution and not just from the plain words of the statute. If the only thing that mattered were the dictionary definitions of the words in Chapter 440, we can be replaced by chatbots. The law is something more than just the words. And if I can't confidently answer
So
my
the law
clients,
also includes what judges say it is, even if it means amending the statute that has been enacted by the elected representatives?
that's a loaded question, the way you phrased it, Judge.
Well, but that's what if we're going to talk about, if our job primarily is to find what the law is and be accurate about it and apply the policy that the legislators have enacted through the process set out in Article 3 of the Florida Constitution, then isn't the first question always, well, what is the actual law? And is it wrong? Is what a court has said about it since then wrong? And then we can get into a policy discussion whether there's good enough reason to reverse or not reverse or overrule that. But the first question, shouldn't it be, what is the law? And what is the law? What does toll mean here? What was the policy enacted in 1994 by the legislature?
That's why I'll get back to my procedural idea, Judge. I'm not suggesting that you can never second guess or revisit a decision that this court makes. In fact, I think you're obligated to reconsider and determine whether a prior panel's decision was incorrect.
The U.S. Supreme Court's done it 230 times or something.
Right.
Right, it happens all the time.
Totally agree, but the Supreme Court doesn't have to go en banc. The Supreme Court's en banc all the time. And so, and Judge, I know you have written that this requirement that the court go en banc comes from, as you described, absolutely nothing. But
Some of us disagree with that, Mr. Rock.
and Judge, I was pleased to see that you did disagree with that in that Awolowo case that I mentioned earlier.
I think I said that about the prior panel precedent rule.
Well, if I got it wrong, Judge, I
But that's-
apologize. But
Same idea, though.
it's the same idea, and I use the phrase, judicial restraint. Choosing to go en banc to make a decision is an exercise of judicial restraint to make sure, and the rule says, and I know the rule says, the en banc rule says may, absolutely says may. You don't have to go en banc. But why would you go en banc? And there's two reasons. And one of them is to maintain uniformity of the court's decisions. And I suggest that while it's not constitutionally required, it is certainly appropriate. So
you'd be okay if we went on banc and changed it?
I would be disappointed because regardless of the validity of your construction in Ortiz about how tolling works,
It wasn't mine, it was the Supreme Court's description. But
understood, my mistake. It is an almost impossible task, not impossible, a very, very difficult task to calculate because of the nature of our cases, the statute of limitations. This is not in the record, but I recently did a seminar for 14 claims adjusters. I spent an hour explaining the Ortiz two-timer tolling. I gave them a simple example, asked for, tell me when the statute ran. All 14 got it wrong.
Well, but now you're hitting on, I think the real issue here is, so your position is well, the way that Philip came out, it makes it easy for your adjusters to enforce the statute of limitations. And what I'm failing to understand is, why is it an adjuster's job to do any of that? Shouldn't they just be adjusting the claims, paying the claims? And a statute of limitations is a defense if someone files a PFB. Where you have it now is that the adjusters are doing it themselves. And was that what the legislature intended when they amended the statute and made it and added tolling? If they added the word toll, and toll has a specific meaning, it means suspension, and the Supreme Court has described how this works. That it is actually the stopping and starting of a clock, and then you add it up. And then there's extensions, which is different, and you can do both in the same case. That's for a court or a JCC to do after the fact in an affirmative defense, not for an adjuster necessarily to do.
Well, except the adjuster waives the defense by not raising it in her first response. So the adjuster has to understand the statute of limitations, and they don't have lawyers most of the time when these petitions get filed. And they have to understand it because the statute says they waive it if they don't raise it. Now, in my 2 minutes.
But they also have the claims run. So they know when the accident happened. They know when the first benefit was provided. They can.
But then they have to use the countdown timer, and then they have to toll it. It's a very, very complicated. Can I make one more point in my remaining 2 minutes?
You may.
Tolling does not apply in this case at all.
Well, you mentioned that, and that would make it easy on us,
Yes, it would.
an easy out, but you're arguing there that compensability and MCC are the same thing.
I am
but
not.
But they're not. I mean, you would agree that MCC and compensability are different things, right?
Well, here's what I'm going to rely on, the plain language of the statute, because compensable is defined in the statute. It means a determination by a carrier or a JCC that a condition suffered by an employee results from an injury arising out of the employment. That's the statutory definition. What happened here? Well, in February 2023, my client denied the case in its entirety, asserting that the condition from which the claimant now suffers, arthritis, did not result from an injury arising from the employment. What does their petition seek? What does their petition seek? Plain language of the petition for benefits says, details. Claimant seeks compensability of claimant's injuries. So I assert, and the judge made this finding in his motion, in his order on the motion for rehearing, that this is a compensability dispute. It involves whether or not this lady's underlying arthritis is covered by this claim.
Well, and again, that would be an easy out for us, but the notice of denial, the work-related injury is no longer the major contributing cause for ongoing treatment of her right knee. Incident which occurred at work, paragraph 2, is no longer the major contributing cause, meaning at one time it was, and the accident was compensable.
Okay, well, but the accident is not a compensable thing. The injury is what's compensable. That's what's compensable, an injury. And here's what this, again, I'll go back to the definition, Judge Bilbrey. It says that a condition results from an injury arising out of. Results from, that's caused by. So it incorporates a causation standard in the definition, the statutory definition of compensable. It's right there. And so this wasn't a claimant's not entitled to TTD. But the statute says, if you want to talk about the plain language of the statute, it says tolling does not apply to 3 things: impairment, MMI, and compensability. And think about this. If the only thing compensability meant, Judge Bilbrey, was whether or not the claim was covered in the first place, there would never be a tolling event. There's no reason to say that tolling doesn't apply to a compensability issue, because if we haven't picked up the claim as compensable, there has been no provision of benefits, nothing to toll. So tolling can only apply in the way that I'm suggesting it does, or compensability can only be considered in the way that I'm suggesting it does. And you're right, Judge, it's the easiest out of this case. We don't have to go in bonk. We don't have to directly take on this contrary holding in Phillip by simply saying that tolling doesn't apply to this case, because the claim was for compensability of the claimant's injuries. That's what's in the petition.
Can I just get one thing from you, going back to the main issue about toll?
Yes, sir.
Going all the way back before Best, do you acknowledge that, had we to do it over again, that the term toll means suspend, and that this use of saying toll means toll or extend was wrong? As an original meaning, just going back to the original use of the term toll as it was commonly understood,
Well,
were the panels
I'm gonna
wrong?
push back slightly, okay? Because the Steele case is the one I cite, but it's Steele versus Commissioner of Social Security. It's 2024 Florida Supreme Court case. And that's the one that said, to arrive at a fair meaning of a term, we consider what a reasonable reader would have understood it to mean at the time of its drafting. And if we consider a reasonable reader anyone involved in the workers' compensation system, we knew what tolling meant. It meant to extend.
Then why change the statute? I mean, they could have just adopted the way it was before and made tweaks to, make clear that there's not a revival of it. something like that, but they fundamentally
no
changed the
idea.
terminology and used a term that is commonly known in civil practice to mean suspend.
Okay, my only response to that, and I realize I'm in excess of my time, is that, and I quoted it in the brief, why was the 94 law changed? They wrote whereas about 20 times, and every single one of their whereases was that the system is out of control with cost. We must take dramatic action to reduce the costs of the system. And so the argument that we made in Phillip is you take a 2-year statute of limitations, and if you give somebody medical treatment on day 1, you've converted it to a 3-year statute of limitations. And the way that you have described in Ortiz tolling, we get 5, 6, 7-year statutes of limitations because of the way that this math works. And so what they effectively did, if you're correct, is they extended dramatically the statute of limitations, which is exactly the converse of what they were trying to do by reducing the costs of the system and reducing the cost of insurance.
But even in Ortiz, the way that you argued it, it was a 20-year extension. I mean, she was getting benefits for a very long time. The accident happened 20 years prior, roughly. So, I mean,
But I still-
even under your reading with the continuous tolling, you're getting that period of time. It's just, this is a functionality, like just applying the statute as it's written, not this is completely foreign and the statute is always going to be 2 years. It was never written that way. It's never been that way.
Well, Your Honors, the last thing I'll say is we have a clear and express holding in Phillip as to how the statute works, regardless of whether we think that's right or wrong. And I'm asking you to enforce it, or I'm asking you to affirm it. Thank you.
Thank you, Mr. Wagner. And let's add 4 minutes to Mr. Porche's time. You don't need to use it all.
We'll find out. I would like to address first the legislature passively adopting an interpretation. There is no interpretation in Phillip. They do not interpret the word toll. They do not talk about the mechanics, how they arrived at it. And specifically in this case, I raised issue 2, which is, okay, let's assume that toll means extend. And it does in one sense, depending on how you're looking at it. But mechanically, how does it extend? You can't just say extend. Some math has to be involved.
Well, and that's Mr. Rogers' point, is that how then does a claims adjuster or somebody 2 or 3 years down the road
Sure.
discern whether this claim should be payable or not? If there's different clocks and, it's like a speed chess game, the clock is starting
If you
and
gave me
stopping.
20 minutes, I could program it in a computer, although I'd have to use BASIC. It's quite easy. It's quite easy. And I explained in my brief that, with respect to the clocks, because few people, watch the passing of days by looking at second hands, a calendar works. And it's really easy. It's difficult only if you're clinging to the paradigm that toll might mean a very vague form of extension where the mechanics are unknown, where it's black box. And so they've used the result to force the mechanics rather than studying the mechanics and then figuring out the workaround. And the workaround is very simple. I put it in my brief, and I was not trying to say, oh, this is the Bible, but it's in response to their arguments. It's pretty easy, because if you have payments that are more than 365 days, and that takes no math. I mean, it's either 1 year or not 1 year. If you have payments, all you have to do is subtract. That from that 365, and that's your deduction. But if it sequentially goes uninterrupted, 365 days of payment without it, there's no statute of limitations to think of. And to Judge Tannenbaum's point, the adjuster doesn't have to worry about that. But, I mean, everybody here has I don't know what they call them, an alarm when someone steps on their front porch. I'm pretty sure that if we have a clear understanding. But Phillips did not decide anything, and the legislature can't say we adopt that, because then we get to the second part. Okay, what are the mechanics?
If
From the date of such payment has never been interpreted. So now Phillips is very incomplete, and we wouldn't use, I can't say that. One would not suggest or encourage using an opinion where they said, yeah, there's no definition in the statute, therefore we're going to make one up.
If toll can mean both pause and extend, either one, why is it unfair to look at the 1994 legislative findings that say the costs are out of control, we got to cut this down?
Oh, sure.
Need to keep, we're about to lose the whole comp system. things like that.
Because at that point in time, you start veering into the falsity of statutory interpretation where you're looking at legislative moods. There cannot be one cost that can be associated with this for good or ill. If you give it to me, so there's many things that were given to the claimant in 1994 that weren't cost measures, meaning not substantive benefits. The 120-day rule, for instance. A statute of limitations that allowed you to treat in accordance with the medical needs rather than clock setting resets. There are some good things out of workers' compensation, and thankfully they did come up with the 120-day, so we're not 20 years down the road arguing for these things.
Well, also, I mean, I had asked at the beginning if you know of a case where in Florida where tolling has been expressly said as a matter of Florida law to mean either toll or extend, as opposed to having just toll mean toll, which is what everyone understands to mean and what the U.S. Supreme Court has understood it to mean since the 1980s,
Right.
if not earlier, and what the Florida Supreme Court has understood it to mean in the 1990s and the 2000s. So we're talking about a premise that hasn't necessarily been established, right? That toll means toll or extend? That's only according to the first DCA, isn't it?
I think you could casually say it extends to the outside observer because
How?
because you're not doing the mechanics. It
Yeah, but
has
you're
no-
getting into now you're getting into the practical or the reality of
Sure.
Sure, as a matter of
the
time,
net
but
effect is that, but it
functionally-
doesn't tell how. How does it give you more time?
Functionally, toll
Functionally,
means-
it
means
can
suspend.
only mean pause or suspend. It can
Right.
only mean that.
So
and I should have been
assuming-
more direct with
so
that. I'm sorry.
assuming, let's just assume that Best and Phillip and all the other cases that have cited it since then are wrong, and that the statute means what it says. The toll means suspend.
Sure.
And let's also assume that the prior panel precedent rule is not really a rule, it's a judicial policy, and it's really just the same thing as stare decisis, and we have to go through all the considerations like set out in Poole. So if we adopt Poole as the perspective, what's your response to, I mean, what I hear Mr. Rogner saying is that, look, maybe it was wrong back then, but there are all these policy reasons why, despite it being wrong, there's ample reason why we should not overrule that concept, such as everyone's come to rely on it. We don't know how to do these calculations now. It's so complicated. I mean, whatever it is. Or
Yeah.
adjusters will go mad, whatever.
Well,
that
I
is.
think that those are all policy arguments that need to be addressed expressly by the legislature, not
Well, no,
infer-
but if we're deciding
Oh.
whether to, go
Oh,
back
I
to
see.
the original meaning, how do we deal with that?
My first suggestion was we start with the statute, and I don't see the policy. If you cling to the old meaning of toll, I mean, we're here right now. This is an expense under the, if you cling to the old meaning of toll, which has really no meaning, I mean, it simply has no meat.
I mean, is the entire place going to fall apart if we went back to the original meaning of toll? I mean, is the entire work-on system going to collapse?
Not at all. In fact, there could be some instances where they would save money because you don't have to get the clock resetting. So first of all, it's only going to apply to cases where there's a permanent injury, for the most part. It is not going to apply to frivolous case. If you're bringing a case for the first time 3 years after, the law takes care of that. Second, the only thing that happens is the person gets to have the case decided on the merits. And one of the things they have not talked about is the pre-94 law was syntactically different, and there was two different points.
Mr. Porcher, your time's expired,
Oh.
so if you could briefly conclude.
I don't know that I can briefly summarize this. Your Honor, I think it's fair to state that Phillips stands, but it does not decide the issues in this case vis-a-vis the mechanics, especially with respect to issue 2. And toll means toll. Thank you.
Thank you.